Hey everyone, and welcome to today's video. Today, we're covering two court cases involving sovereign citizens. One of them is new, and the other is someone many of you already recognize. Someone who keeps finding their way back into legal trouble. We'll begin in Conato Municipal Court with a sovereign citizen defendant. As you watch this hearing, keep one important detail in mind. A group of school children were seated in the courtroom that day as part of a field trip to observe how the justice system works. Let's just say they got a very memorable lesson. So, let's get started.
Court is now calling City of Conneaut versus Amber McHenry, case number 24 TRD 819.
Ma'am?
I'm sorry. I'm just trying to get my stuff situated so it's ready here.
Take a seat
I have a question.
in this blue chair.
Do I have the
Sit down.
Do I have the same rights?
You want me to hold you in contempt? Sit down in that blue chair.
Do I have the
Sit
same
down.
rights there?
One more time. Sit down. Now you'll answer my questions. Got it? Did you understand all of the rights and plea options that I explained to you?
No, I do not understand.
Okay. Then I will enter no plea to the charges
I object.
filed against you. Well, let me just explain to you. You are charged, and I do have a signature on the citation which shows you've been served. You are charged with one count of no operator's license, a minor misdemeanor subject to a maximum fine of $150 plus court costs. You also are charged with one count of expired plates, also a minor misdemeanor subject to a maximum fine of $150 in court costs. I will enter no plea to these charges against you. You already have a pending. You already have a pending.
I object.
What do you object, ma'am?
Because I did not enter that plea. You're
Okay, so
entering
you
that
tell
plea.
me how you would like the plea: guilty, not guilty, or no contest.
First, I have to correct the standing, which is I am not the ens legis non degear. I am the authorized agent to the decedent estate. I am coming in here as the settler, and I want to settle this case.
If you truly believe that laws, courts, and basic civic rules shouldn't apply to you, then this probably isn't the system for you. In the United States, society operates on shared rules that apply to everyone, whether we like them or not. Those rules aren't optional, and they aren't suspended just because someone disagrees with them. People reject the legal system outright while still benefiting from living here. The result isn't sympathy, it's disbelief and criticism.
I have sent in a paper that is my declaration and affidavit of what I want to do, which is to settle the case. I am willing to surrender the person to the court for mutual consideration. I do not want to continue doing this. I don't have anything to do with this. That paper that I signed, which is the summons, is signed v coatis, which is void contract, and I reserved all of my rights on there. So, is the court willing to give me mutual consideration today or not?
I will enter no plea on your behalf to these charges. I've given you 3 plea options to plead.
No, I do not recognize anyone in this court.
Okay, well,
I don't recognize you or the bailiff or anybody else in this court. I do not understand.
I will set this case for a bench trial, and we'll get this set.
I have the right to a trial by jury.
Okay, no you don't, not in this case.
Yes.
Now these are not jailable offenses, ma'am. You don't have a right to a trial by jury in this case. You already have a jury trial scheduled in another case, but then because you're facing jail time in that case. But in this case, you're not facing jail time, only a fine and
Anything that is above $25 in a court of law has the right to a jury by trial, which is involuntary. can't be violated, basically, is what it means. So I have the right to a jury by trial.
No, you don't.
Of my peers.
No, you don't.
Yeah.
We're going to set it for trial, and you're going to go to the clerk's window, and they're going to give you a trial date. Okay? So
then I'm just going to surrender the person to the court because I'm not coming back.
I don't know what that means.
You do know what that means.
I don't know what that means.
I am not the ens legis, non de guerre. I told
I
you that.
don't know what that means either, ma'am. I've been practicing law for 36 years, and what you've just said to me has no meaning to me whatsoever.
Well, Your Honor, if you spent less time on wild tangents and more time reviewing the facts, maybe this wouldn't be so confusing. School. I don't know, Judge. You might have gone to law school and drafted a few trusts, but Karen here is over in superglue Somalia, actively trying to light up her own version of sovereign law. I think one of you might be out of your league.
So,
great.
Yeah.
So
ma'am, if you don't leave the courtroom, and if you don't go to the clerk's window to get a trial date, I'll have you arrested and hold you in contempt of court.
With what contract?
There is no contract.
I know
You're looking at the contract. You're looking at the one who's going to be able to, has the authority to be able to put you in jail, and I'll hold you in contempt. So let me say it one last time, because we have other cases to handle today. If you don't leave the courtroom and go to the clerk's window and get a trial date, which is what I'm scheduling in this case, I will hold you in contempt of court and I'll have you arrested.
So, contempt of court for what? What contempt?
For not doing what I'm telling you to do, which is to go to the clerk's window and to get a trial date.
You're the trustee and I'm the beneficiary.
No, there is no trust relationship here.
No, there isn't.
I've drafted many trusts, and there is no trust relationship between the judge and you, the defendant.
Yeah, because
you are not the beneficiary, and nor am I the trustee.
Yes.
Yeah, that's just not how it works, man.
It
Not
is.
how it works.
I love how this trog Ken brought her hobbit-sized Neenderkin along. I'm curious if he'll reach full size by the time her trial starts. Alright, that wraps up that video. Now, let's head to Judge Shackelford's courtroom for a visit with our favourite sovereign dick flute of all time, Eric Martin. Many of you remember that a few weeks ago, Judge Slavin sentenced him to a short stint in jail for some other charges. Despite the obvious lack of jurisdiction, he got released, and it only took 24 hours for him to violate his bond conditions on the domestic violence case and get thrown back in jail.
You either go to the clerk's window now and get a trial date, or I'll have you taken into custody now. You got it?
Is this your phone?
Let me stop you right there. Do you see where you are? And do you see where she is? Jurisdiction confirmed. Not to say I told you so, but when Eric Martin was brought in for his first bond violation, I pointed out that he doesn't recognize the court's jurisdiction. So, was anyone actually surprised that he ignored that order? And are you really shocked that he's back in jail?
All right, this is 242448 SM, the People versus Eric Martin. Mr. Martin, can you tell me your name?
Roman cystic that's what you're wondering.
Okay, I recognize Mr. Martin. Mr. Martin, it's my understanding that Mr. Coots, an attorney, a defense attorney, attempted to meet with you to go over your rights and that you did not want to meet with him. Is that correct? Yes or no?
Well, at first I did, and then I kind of changed my mind. I'm still in the sense of not giving you guys the fraudulent presumption that you got jurisdiction over me when you don't.
Well, you can demand your release in one hand and __ in the other and see which one fills up first. You are in no position to demand anything. They've already tried that, and you've shown, time and again, that you have zero respect for the court and a total inability to follow orders. The only thing that's going to be dismissed today are the ramblings of a 50-year-old toddler.
That's why I don't want to take it, but
So
I'm
no.
getting kind of fresh too because
I'm going to mute you so I can tell you your rights, Mr. Martin. I need you to listen. So here are your rights. You've been brought to court on an allegation of a bond violation. Specifically, you currently have a domestic violence case pending at this court in front of Judge Slavin. And on that case, the complainant is Kirk Martin. There was a no contact provision. And that was one of the conditions of bond. And there is an allegation that on December 14th, so just this weekend, that someone called from the residence of Kirk Martin and indicated you were in the home. And the officers alleged that you were, that they checked and that you had bond conditions out of this court saying you weren't to be near him. And that you were taken into custody, for violating your bond conditions of no contact with Kirk Martin. These are allegations at this time, but they're serious allegations in violation and no contact provision. So do you want me to enter a plea or do you just want to ramble about jurisdiction? I'm going to ask you to unmute so you can answer my question. Officer Ziegler, I'm sorry, can you unmute? Mr. Martin, you have options, so you understand that's what you're here on. You can plead guilty, not guilty, or you can say nothing and I'll enter a not guilty plea on your behalf. So to the allegations that you violated the conditions of your bond for purposes of arraignment, how do you plead?
first I want to notify crimes. Before I get to that, I want to notify crimes committed against me in the jail here since I've been here, such as criminal harassment.
Okay, I'm going to enter a not guilty plea on your behalf.
I'm not done talking.
But your answer is non-responsive.
Violating my First Amendment right, freedom of speech. And this whole bond order condition, it violates my due process right to be free at my house, which is based on an unsupported lying allegation by my brother. Therefore, this is all violation of my due process rights. The bond order should have never been done. This is all unconstitutional. The case should be dismissed, and I demand it be dismissed. Now.
You're literally going through your due process as we speak, you idiot. Part of that due process is following the conditions of your release on bond, which you've failed to do repeatedly. That's exactly why they're not going to let you out on a PR bond. School. All right, so for the foreseeable future, Eric Martin's family will enjoy some peace and quiet while he enjoys an extended stay at the Mugshot Motel. As for the 2 hearings we just covered, I'll be sure to bring you updates as they come. If you liked the video, hit the like button. If you didn't, hit dislike. Don't forget to leave a comment below and subscribe with notifications on so you never miss an update.
All right, so sir, you have a right to a hearing on this matter. You have a right to receive written notice of the violation. You have a right to plead guilty, not guilty, or stand mute. I've entered a not guilty plea on your behalf since your response was non-responsive. You also have a right to contest the charges at a hearing. You do have the right to the assistance of an attorney at all subsequent court proceedings, and you can change your mind at any time, Mr. Martin. You have the right to have that a lawyer appointed at public expense if you are unable to afford an attorney. And it's always possible that if the court determined you were able to pay, that you would be required to contribute to that cost. If you continue to proceed without an attorney, you would give up your right to a lawyer's assistance. We will set the hearing. I'm required to set that hearing on that violation if you are in custody We must hold it within 14 days of the arraignment, which is 14 days from today, or the court must order you released pending that hearing. If the alleged violation is based on a new criminal offense, that is set basis for separate criminal prosecution, I don't have any knowledge that that's the case here. The court could postpone the hearing for the outcome of that prosecution. You have a right to contest the allegations against you. You would have a right to have the evidence against you disclosed. You'd have the right to present at the hearing, or to be present to present evidence, to examine and cross-examine witnesses. The court would only consider evidence that's relevant to the violation, but it need not apply the rules of evidence except those pertaining to privilege. The prosecuting attorney would have the burden of proving the violation by a preponderance of the evidence. If you pled guilty, you'd be giving up your right to a contested hearing. And while this case is pending, you could be, the most severe violation is you could be held pending the hearing, and if found guilty of this violation, you could be held while this case is waiting for jury trial. So those are your rights, Mr. Martin. Mr. Martin, I understand your sovereign arguments. I mean, it's fine. You can make them. I've heard them before. Everyone at this court has heard them. But here's the thing. I can't have you, if there is a no contact order and you continue to violate the no contact order, I can't let you out because you're not listening. And I know you don't think you have to, because you don't